In this case, there were 3 challenges, and I was required by law to hold a hearing, an administrative hearing, to review the evidence, hear testimony. Both sides were represented by counsel. Mr. Trump was represented by an attorney, and then I'm required to issue a decision. That's my obligation under the oath I swore to the Constitution.
In terms of the criticism that your decision takes away the right for voters to have their voice heard, do you believe that's a valid concern?
Again, my first and foremost obligation is my oath to uphold the Constitution and the rule of law. Now, different states are different. For example, in neighboring New Hampshire, there are more than a dozen candidates on the Democratic presidential ballot, but Mr. Joseph Biden is not on the Democratic presidential primary ballot in New Hampshire, and there are more than a dozen Republican candidates. In Maine, there are 2 candidates on the Democratic presidential primary ballot and less than a dozen Republican presidential candidates. So every state is different. My obligation and duty, my sole consideration, is my oath to uphold the Constitution.
This is Michael Popok, Legal AF. You might have woken up to the headline that said that the Maine Secretary of State, Shanna Bellows, has ruled under the powers given to her by the Maine Legislature to remove Donald Trump from the ballot in the primary and presidential ballots as president, because in her determination, after a week-long hearing, Trump made false statements on his petition to be on the ballot, namely that he was qualified to be on the ballot. And after taking in all of the evidence, including the Jan 6 report, which was a major piece of her analysis, Shanna Bellows determined that Donald Trump engaged in an insurrection by inciting the riot that interfered with the constitutional duties of Congress. How did we get there? What are the key points of her ruling? And what happens next, particularly not only in the Maine court system, in the next 2 steps that have to be done before Donald Trump could even take an appeal to the United States Supreme Court. But what is the U.S. Supreme Court going to do? What are the main issues that are going to be up in front of the Supreme Court in January about states like Colorado and Maine, who through different processes, different statutes, got to the same place ultimately? Although Shanna Bellows gets the award, gets the blue ribbon for being the first Secretary of State to actually ban Donald Trump from the ballot. He is banned, as of right now, primary and presidential ballot. Colorado's Supreme Court ruled that the Secretary of State of Colorado can ban Donald Trump from the ballot, but that decision has been stayed. A pin has been put into it until the U.S. Supreme Court appellate process runs its course, meaning in Colorado, Donald Trump's going to be on the ballot in going to be on the primary ballot for the Republican Party in March. Let me go back to Shanna Bellows. First of all, she's getting attacked mercilessly. We'll put up some social media here, of course, from Stephen Chung. I'm not even sure Stephen Chung really exists, but there is an entity called Stephen Chung that seems to represent Donald Trump when it's not Alina Habba, the lawyer, and he comes out and said it's anti-democratic. She's a partisan hack. Shanna Bellows, ignore her. There's nothing to see here. Well, first of all, let me just respond to Mr. Chung this way. Donald Trump made a decision. He made a decision, either that or he's asleep at the switch, not to actively participate in the Maine process by which Shanna Bellows, the Secretary of State, Secretary Bellows, made her decision. What do I mean by that? He had the opportunity, but did not take the opportunity to present evidence, to bring in witnesses, to bring in experts, to bring in documents. All he did was submit 2 briefs. One brief on I'm qualified and you don't have the power and you're biased and you should be disqualified, Secretary Bellows, and another brief after she asked for it about whether the Colorado Supreme Court decision was relevant to her decision-making. That's it. The other side, the 3 former members of the Maine Legislature, 1 independent, 1 Democrat, and 1 Republican, they are the petitioners. What did they submit? They submitted the Jan 6 report as evidence, all 370 pages of it. They brought in experts, including ones that were used in Colorado, to testify about the meaning of the term insurrection, the meaning of the term rebellion, the meaning of the term inciting, the meaning of the term, and what does the 14th Amendment, Section 3 mean, and is it self actuating, self-affecting. That is the nub. That is the rub that's going to go to the U.S. Supreme Court. We all know now what the 14th Amendment, Section 3 says, that if somebody engaged in insurrection or rebellion against the Constitution, right, he's disqualified. He or she is disqualified from serving in an office where they had once raised their hand to defend, swear, or protect or preserve the Constitution. We know what it says. The question is, who gets to act on it? It's on the books, right? It's in an amendment from the 1870s. What do we do with it? And who has the power to ultimately decide it? Is it a state-by-state decision, as Secretary Bellows and the Colorado Secretary of State has ruled, based on a line of Supreme Court precedent that says that the states have an active role in deciding in presidential elections and presidential elector standards? They have the role to regulate in that area. May seem odd because we're in a federalist system. Sounds like, well, it's a federal election, so maybe a federal agency should be responsible and not the individual states. But in that delicate balance of our federalist system between the states' rights and the power of the federal government, that's how they sort of solomonically divided up responsibility. The feds Congress handles certain things, and the president of the Senate handles certain things related to certification. But at the lower level, how elections are run, what ballots look like, what's the hours of operation for election day, right? What's the process and logistics for voting? That's all at the state level, which means the Secretary of State level for each state. That's why when you call your friend in another state, they're voting in like a different way. I'm using electronic ballot. Oh, I've got a paper ballot. Oh, my hours are 7 a.m. until 12 at night. Oh, I only got 6 hours to vote. Oh, I can vote on the weekend. Oh, I can't. Oh, I can do mail-in and drop it off. Oh, I can't. Why? Because we have a patchwork quilt system, a patchwork system state by state, because of the body of law coming out of the U.S. Supreme Court that says the states have a role in administering and administering this process. This is what we saw in Bush versus Gore, right? That's why Bush won. Florida had a certain process. It came down to Florida. And there was a fight that got settled at the Supreme Court level in 72 hours of briefing and oral argument, 5-4, that Florida was not interpreting its own laws properly about how to count certain ballots. If those ballots have been counted, Gore wins because the count was stopped by the Supreme Court because they found that due process violations in aspects of the Florida law, but there's Florida law, and just like there's Maine law. I'm going to get to the opinion in a minute, but I want you to understand first the context of what we're talking about. States, secretaries of states, are charged under our Constitution and under interpretation of our Constitution with regulating who gets to be on the ballot, who comes off the ballot. Even Justice Gorsuch on the U.S. Supreme Court, when he was on the 10th Circuit, and ruled in a case called Hassan, which is cited in Secretary Bellows' own decision, even he said that it's up to the states to make those ultimate determinations about who gets to be on the ballot or not. Now we'll have to see what he says at the Supreme Court level. But back to Trump's failure to participate properly in the process. Donald Trump could have brought a witness, could have brought an expert, could have submitted evidence. He did none of those things. The other side did. They brought in experts. They brought in the Jan 6 report. They had testimony. They had documents. So she had a record in front of her, even though some would argue it was slightly incomplete because Donald Trump took his ball and went home. You never see that mentioned by Stephen Chung or the spokespeople or Alina Habba on television, that he didn't participate properly. He just filed a brief. But the secretary here, because she makes the ruling first. Now, some people might be saying, why does she get to make the ruling first? Why isn't this in court the way Colorado is? And again, we're back to my original observation here on this hot take. This is a state-by-state unique process. The waterfall that each state uses to determine through its statutes, right, the decision-making tree is determined by state law. And every state is different. We have 50 of them. Okay, so that's why we're getting different results. It's all going to come to a head at the U.S. Supreme Court. I'm going to talk about that at the end of the hot take. But let me finish up with Shanna Bellows. And I'm pronouncing her name, I think, right, because I got it off of Facebook with a video of her saying her own name. For those people in Maine who follow Legal AF, you can tell me if I'm right, but I don't think it's Shenna. I think it's Shanna Bellows. Let me talk about Shanna Bellows for a minute before I get into the nitty-gritty of her decision. Who is she? If you listen just to the other side, the MAGA, she's a partisan hack that works for Joe Biden and she's a puppet. No, okay, forget all that. She has her own, that's another misogynist undermining of the value of a woman in leadership by the Trump campaign. I mean, I could spend an entire week of hot takes giving examples of what I just said, all right? And lawsuits, including E. Jean Carroll, that Donald Trump is going to have to pay tens of millions of dollars because he's wrong. But Shanna Bellows, let's talk about her for a minute. Where did she come from? She was appointed by the Maine State House, by the legislators in Maine, to be the Secretary of State. She doesn't run for election of the Secretary of State in Maine, like in other states. Again, the differences of states. She gets appointed. She gets selected. And what was her body of work? It was substantial. She was the director of the Holocaust and Human Rights Center in Maine. She was the former head of the American Civil Liberties Union in Maine. She also worked for the Maine American Civil Liberties Union as an organizer in Washington, D.C. She was in the state house itself for Maine, in the legislative house for about 4 years until she was selected from that same house to be the Secretary of State. She has a very humble background and beginnings, in contrast to Donald Trump, who was born to paraphrase Ann Richards, the late Ann Richards, governor of Texas, with a silver foot in his mouth. Shanna Bellows is the daughter of a carpenter and a nurse. She did not have running water or electricity in her house until the 5th grade. She is completely self-made. I mean, I'm sure her parents gave her values and all that, what they couldn't give in material goods. But she is self-made. She has a degree in economics. She was in the Peace Corps. She was in the AmeriCorps system, and she has just devoted her life to public service. And this is just another extension of that. I think she's about 47, and that's her background. She's not a lawyer by training in her background, but she doesn't have to be. She has lawyers on her staff that can advise her, and I'm sure helped her put together her package the way any Secretary of State would rely on their counsel. Now, let me get into the nitty-gritty of the actual order, and then I'll talk about at the end the Supreme Court, because I think there's aspects of the order, the decision, if you will, that are really, really important. Right off the bat, sorry about that, I'm scrolling through the ruling of the Secretary of State. She says on page 1, for the reasons set forth below, I conclude that Mr. Trump's primary petition is invalid. I find the declaration on his candidate consent form is false because he is not qualified to hold the office of the president under Section 3 of the 14th Amendment. That's where she starts. She then goes through the unique elements of the Maine set of statutes that she has her power under, which, just to bore people, is 21A Maine statute sections 336 and 337. For those who want to fall asleep at night, you can take a look at those on your off time. She says for the hearing, she relied on looking at Trump's original petition, his consent form, the challenges filed by the 3 former members of the State House that span all political parties, the notice of hearing, and all the exhibits, including the Jan 6 report. What she didn't get was any testimony from Donald Trump, any expert opinion from Donald Trump, any evidence submitted by Donald Trump. And whose fault is that? Donald Trump. She says, and she continues in her briefing, that the central question for her is to determine whether Donald Trump violated the 14th Amendment, Section 3. And she acknowledges, and she cites too on page 11, Justice Gorsuch's own decision when he was a 10th Circuit judge in Hassan. And she says, for those that question whether the states have the power to determine the qualifications of a presidential candidate, she then sticks it to Gorsuch right away and says, as now Justice Gorsuch observed in Hassan versus Colorado, a 10th Circuit case from 2012, quote, a state's legitimate interest in protecting the integrity and practical functioning of the political process permits it to exclude from the ballot candidates who are constitutionally prohibited from assuming office. I'm gonna have fun watching Gorsuch squirm away from that decision making if he tries to take the position that states have no role in the 14th Amendment Section 3 analysis. So that's her first starting point. She then goes on to say on page 16 and going over for another 15 or 20 pages that Mr. Trump engaged in insurrection against the United States such that he is not qualified to hold the office of president. I quibble with her just a bit. The insurrection under the 14th Amendment, Section 3, as even former Judge Ludwig has said, is a rebellion or insurrection against the Constitution. She short-sights it as the United States. It's close. Doesn't really change my view of her analysis, which is rock solid, but I did want to make that one comment about if I were retyping that particular header, I would have said against the Constitution. She also goes on to say that her state law provides an appropriate process to adjudicate the qualifications of a presidential candidate under the 14th Amendment. In other words, the states each have to deal with how they're going to address the 14th Amendment Section 3 disqualification clause, and if there's going to be a process. And she cites that there is a process in Maine, and that under that process, the Secretary of State, has the ultimate authority. And now we're into states' rights. And so she then goes on in describing how the 14th Amendment Section 3 works. She takes the position, as did Colorado, that it is a self-affecting provision. In other words, there's no congressional further action that's necessary. It's self-executing without any ancillary legislation at all. And she cites a series of cases from 1883 at the Supreme Court level that stands for that proposition. She then says that, yes, under the Constitution, under that same Article 14, there is a Section 5 that says that Congress shall have the power to enforce by appropriate legislation the provisions of this article, but that doesn't mean, as she says on page 19, but that does not mean that action pursuant to Section 5 by Congress is a prerequisite to the substantive provisions of the 14th Amendment having any legal force. Indeed, champions of the Section 3 enforcement mechanism that Congress briefly authorized questioned whether it was necessary at all. So now she's standing firmly on the ground that states can make this decision, not Congress, under the legislative history of the 14th Amendment, Section 3, and its own language. And I think she's on solid footing there. She then goes in to talk about the record about Jan 6th and what happened and the insurrection against the Constitution and Donald Trump's role in it. And she does that for about 10 pages. She then concludes that he has committed inciting of an insurrection and a rebellion, which is a violation of the 14th Amendment, Article 3. Now, she says on page 24, here's Trump's response to that. Mr. Trump criticizes the expert opinion offered by the other side and their definition as based on sources too weak and disparate in time, but he offers no workable definition. Specifically, Mr. Trump's claim that insurrection must be, quote, violent enough, potent enough, long enough, and organized enough to be considered a significant step on the way to rebellion, and that's from his brief, is both ambiguous as a standard and poorly supported by the evidence he cites. This is from Secretary Bellows. An insurrection, she continues, need not involve military-style weaponry, involve bloodshed, citing cases, or even be highly organized. Nonetheless, even if the insurrection under Section 3 were so limited, she continues on page 25, the evidence here shows that the events of January 6th met that standard. And then she talks about the videos and documentary evidence in the record, the large and angry crowd entering the U.S. Capitol, the assault of Capitol Police, the vandalizing and ransacking of offices, and many of those involved being armed. Some brought weapons to the Capitol, some wrested them from police officers, and some repurposed items looted from inside the Capitol itself and used them as weapons. And then she turns to Donald Trump engaging in that insurrection against the Constitution on page 26, where she said the record demonstrates that Mr. Trump engaged in the insurrection of Jan 6, 2021. And she says basically it is his inciting, his use of his tweets, his social media, the speech on the ellipse to incite violence, to incite and encourage and foment this insurrection and rebellion, that it constitutes incitement of an insurrection. And she quotes extensively from the Jan 6 report about Donald Trump's claims that the election was stolen from him, and his own tweets to tell people to come to the Capitol. It's going to be wild. Peter Navarro has a report that completely says that I lost the election by fraud, and then calling for the march, knowing the people were armed to go to the Capitol. That, at the end, for her, is enough to find that he has violated, and she has the power to determine that he's violated the 14th Amendment, Section 3. Now, let me leave you on this part of the hot take. What happens next? For the Maine case, it's going to have to be an appeal to the Superior Court of Maine. Now we get the court system involved. Secretary of State on the executive side. Now we get the court system involved in Maine. And if he loses at that level on some sort of expedited hearing, he then goes to the Supreme Court of Maine. And then from there, he can take an appeal to the U.S. Supreme Court. Now, he might try to take some sort of immediate expedited interlocutory appeal kind of in the middle here directly to the Supreme Court, given that they're going to be deciding the Colorado decision. I'm not sure they take that ruling. They might think they have enough to make a broader statement about 14th Amendment Section 3 and the role of the states in implementing it, because that's what's going to be up at the Supreme Court. So we'll watch the Maine timetable and see if it kind of marries up and matches up with what's going on in Colorado with the Supremes. The Supremes in January, starting at least on January 4th, are going to take up the case of Colorado. And the issues that need to be decided there, which I'll do in a deeper dive hot take next, is going to be, is the 14th Amendment Section 3 self-affecting? In other words, do you need to go back to Congress and have them do anything in terms of somebody being found to have violated that and can't be on the presidential ballot? Or does it say what it says in the text of the language of the 14th Amendment and the legislative history? That's the first fundamental thing. Is it a political question that has to be decided not by the court system or even the executive branch, or at least not by the court system? Is that a political question, or is it something the court system can handle? Because ultimately, all these lead through a court system. If it's a political question, under the political question doctrine, it'll get kicked back by the Supremes to Congress. And those are your fundamental arguments, really getting down to is the United States, based on federalism, the body of case law leading up till today, going to allow states to individually make decisions, as they always have, about who's qualified on the ballot and how to implement the 14th Amendment, Section 3? Or is that going to be a federalist decision, a federalism decision over at the Congress side? And that is what's going to be decided by the Supreme Court. I would expect sometime in January, at least in the first quarter of 2024, to see if Donald Trump will be on the presidential ballot. So in the meantime, he may end up being on these primary ballots. If he wants to be the GOP representative, and that's what they want, maybe we'll just give it to them. But then the ultimate decision, we've got a little bit more time before the November election to solve that riddle and that issue, and that'll be done at the Supreme Court level. We'll continue to follow it on the MeidasTouch YouTube channel and on hot takes like this one, and follow me on Legal AF on Wednesdays and Saturdays at 8 p.m. Eastern Time on YouTube, right here on the MeidasTouch Network, and then on audio podcast platforms of your choice. Until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.